Yes, Mr.
Yes, Your Lordship. Lordship, I beg to mention item number 6. Item numbers here by the order 19/5/2026, where cost was imposed 2,500. So we have already complied. And affidavit was filed on 9th, but it was technically rejected. So a short time will be given to rectify our affidavit.
Okay, good. 9. Item number 6.
Nineteen 5/2026, that's the last order.
But there was a direction if the affidavit is not filed.
Yes, so we have filed, but it was technically it was rejected. So Your Lordship,
Technically, what?
for annexure and this and that. So we are under rectification.
When did you file affidavit?
9.
9 June.
Yes, yes. Till before yesterday. So yesterday we found rejected.
So when you are going to file?
By Monday, tomorrow is Friday. So by Monday, I can rectify by tomorrow.
Third, Mr. I. M. Shong, learned additional advocate in Nagaland.
Lordship, I'm appearing for private respondent.
And Mr.
Yes, Lelamtong Pim Chungwa.
For the respondent number?
Lordship, there are too many respondents, so I'll just submit.
For the private response. Who is for the petitioner? Mr. Im Song has submitted that pursuant to the order in compliance of the order dated 19/5/2026, a sum of rupees 2,500 has already been deposited on 2/6/2000 on 8/6/2026. Yes, further submitted that on 9/6/2026, the affidavit on behalf of the state respondents who was filed in the registry, but due to discrepancies in the annexes, the affidavit was not accepted. First of Mr. Kim has submitted that he is in the process of removing the discrepancies in the annexure to be enclosed with the affidavit of the state respondent, and has submitted that by Monday without fail, the affidavit of the state respondents will be filed. So, considering the region's side as regards non-filing of the affidavit of the state respondents, the time till 15/6/2026 is granted to the state respondents to file the affidavit. First of Ms. Z. Jima, the petition, and so are present. So when do you want release the case?
Lordship,
On 18/6. You want to file affidavit and reply? File.
Lordship,
Obliged.
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention on behalf of my colleague Livika, item number 15, 16, and 17 from the hearing list, supplementary list. Your Lordship, if this matter can come up after the disposal of writ appeal number 2345 of 2025.
Read appeal to
2345 of 2025.
2345. Four read appeals.
Yes, Your Lordship.
2025.
Yes, Your Lordship, 2025.
No objection, Your Worship.
Mr.
Philip.
Philip, Learned Counsel for the petitioner. All are tagged, right? 15, 16, 17.
Yes, Your
Yes, Your
Lordship.
Worship.
Petitioners is present. First of Miss A.I.M.E. Learned Government Advocate on behalf of Miss Livika. Learned Government Advocate appeared for the state respondents. Has sought for listing of the case. After disposal of 4 writ appeals. Writ appeal number 4 or 2/2025, writ appeal number 3/2025, writ appeal number 4/2025, and writ appeal number 5/2025, wherein similar issues as involved in these 3 petitions, are involved, and the outcome of these 3 petitions would be dependent on the decision taken on those 3 petitions. In view of the counsel for the petition has no objection, has submitted that he has no objection for prayer submit on behalf of the state respondents. Is the case after 6 weeks.
Much obliged, Your
Much
Lordship.
obliged, Lordship.
The cases.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item 3 on behalf of my senior, Gauhati, learned CGC. Lordship, in this matter, we have received the instruction and has prepared the affidavit accordingly. However, certain type copies of the annexures related to the affidavit
How
are,
much time you need?
Lordship, 1 week.
Okay. One.
Lordship,
Miss
objection.
Miss
Grace Namgi.
Learned Counsel for the petition is present, Mr.
Maslezo,
On behalf of Mr.
Gauhati.
Younger with the Learned Central Government Council submitted that the Union of India, the counter affidavit on behalf of the respondent. Union of India response are in the process of being filed, and the same will be filed within 1 week's time. He has just sought listing of the case after a week. Most of the prayer allowed list the case after a week.
Much obliged, Lordship.
Please by the office.
Much obliged.
May I please, Your Lordship? Lordship, I'd like to mention hearing item number 9. My Lord, in this matter, the petitioner is seeking for compensation as per in terms of the Compensation Act 2013. So, my Lord, in a similar matter, the state has filed an appeal as to the applicability of the said act, being writ appeal 7 of 2025. And this Honorable Division Bench has delivered its judgment on 5th of this month. So if some time may be granted for me to go through the judgment.
Yes.
I have no objection, my Lord. My Lord, I'm appearing for response number 2, 3, 4, and 8.
2, 3, 4.
4 and 8.
Give it a break. Miss
Grace Namgi.
Learned Counsel for the petition has submitted that the case be listed
My Lord, if it can be listed on 22nd of this month.
after a week in order to go through the judgment in order delivered in writ appeal number
7 of 2025.
7 of 2025. Mr. Thiva from Learned Counsel for Learned Government for the respondent number 2, 3, 4, and 8, who is present, has submitted that he has no objection to the prayer made. Also, in view of the above, lays the case on 22nd.
Lordship. Much obliged, Lordship.
কথা বলেছে।
May it please your lordship, I beg to mention item number 10, your lordship. Here the leading counsel H. Mukam is at disposal. The matter can be listed after 3 weeks, your lordship. His name is also reflected in the leaf note, your lordship.
Madam, your good name?
Lordship,
Learned counsel on behalf of Mr. H. Mukam. Learned counsel for the petitioner has prayed for listing of the case after
3 weeks, your lordship.
she is on the ground that Mr. Mukam is indisposed.
Yes.
Okay, Miss.
Lordship, I'm for respondent number 4.
Okay, and Mr. Tivapong.
My lord, I'm appearing on behalf of Mosum sir, the counsel for this thing.
Okay, on behalf of the state respondent and Miss Apila Sanktam and counsel for the respondent also. Were present from I have submitted today of no objection to the prayers for adjournments. The prayer is allowed, list the case after 3 weeks, only take 2 weeks by the office.
Please, Lord.
Please, your lordship, I beg to mention item number 18, hearing item number 8. I pray that this matter may be listed after vacation.
Lordship, this matter has been adjourning time and again, Lordship. So I pray that a date may be fixed with no further condition, with no further adjournment, Lordship.
You fix a date after vacation.
Lordship,
Mr. Supon Ukiwali, learned counsel for the petition. And you are 16.
Mr. Shijamir, for respondent number 4.
I'm for respondent number 8.
8, Mr. So-and-so, and Miss Annie, learned state counsel. Are present. The prayer is made by Ms. Jamil for listing of the case on a fixed date after the vacation. Also, Mr. Walling has submitted that repeated adjournments have been sought in this case by the respondent side. Also, repeated as it may come as not fine. Release the case. On vacation will reopen 16 July
Lordship,
is the case.
obliged, Lordship.
Obliged, lordship.
As
From the supplementary cost list for motion, item number 11.
yes,
My pleasure, your lordship. Your lordship, this application is praying for regulation of the petitioner, lordship.
you should notice at this stage, Miss Chan.
Yes, lordship.
Lord Mr. M. Kunian,
Manchongonya.
learned counsel for the petition, and Miss S. Chan,
Yes, your lordship.
learned government advocate. For all the respondents,
Yes, lordship, from 1 to 7.
whereas the petitioner came to be appointed as a vouchers labor on fixed pay in the establishment of the respondent number 7 on 1/4/1985, and after serving the Public Works Department for about 35 years, the petitioner was released from service on 31/3/2020 by an office order. Posted. After his release from service, the petitioner submitted a representation before the respondent of filed on 9/9/2024, seeking skill pay and regularization of service for pension benefits. As till date, the representation has not been given consideration. The petition is before this court seeking directions to the state respondents to regularize the service of the petition and to pay him pension and other retirement benefits. Issue notice for returnable in 4 weeks as Ms. Chan Learned Government Advocate has appeared and accepted notice on behalf of all the respondents. Issuance of formal notice to the respondents is dispensed with. The Land Council for the petition shall furnish requisite number of extra copies of the petition along with next to Ms. Chan within 3 working days from today.
Obliged.
Obliged. For motion, item number 12.
May it please your lordship. Your lordship, here the petitioner is seeking appointment on compassionate ground, your lordship. The petitioner father was appointed on 1999 under Food and Civil Supply. Thereafter, he was granted officiating promotion as driver and redeployed under Labor and Employment Department on 2010,
In a substantive post.
your lordship.
Your father was in a substantive post.
He was granted officiating promotion as a driver.
The petition. But Miss
Shisa Jamir.
Learned Counsel for the petition and Miss S. Chan, Learned Government Advocate for the response. Also, the petition has stated that his father, who was an employee in the Labor and Employment Department, Government of Nagaland, died in harness on 1/1/2019. Following the death of his father, the petitioner submitted an application on 8/12/2025 seeking his appointment on compassionate ground in terms of the policy framed by the state government by an office memorandum dated 17/9/2025. The petitioner has stated that the respondent of host has already prepared a waiting list of applicants who are seeking an appointments on compassionate ground and forwarded the said list to the respondent number 2, wherein the petitioner's name has figured at serial number 1. As there are vacancies in 19 number of vacancies, including 11 vacancies in Group C post. The petitioner has approached this court seeking a direction to the responding authorities to appoint him on compassionate ground on the ground that the application submitted by the petitioner has not been considered till late. Issue notice or returnable copies. Same dispensed with extra copies.
For motion, item number 13.
Your lordship, similar prayer. Here, the petitioner is also seeking for appointment on compassionate ground. Even in this case, the petitioner figures as serial number 1 under Longling District.
Father, an employee in the Health and Family Welfare Department, Government of Nagaland. Mother, petitioner's mother, died in harness on 21/12/2023. Application date 12/7/2024. Then, right, the application was duly forwarded for consideration by the respondent number 4. The petitioner stated that presently, there are 76 vacancies in grade 4 posts, out of which 3 vacancies pertain to Longline district. And further, vacancies are likely to fall vacant by December 2026. Other than office memorandum seen, office memorandum gets it, the things are seen. Issue notice. And
Bless you,
extra
Lordship.
copies.
For motion, item number 14.
May it please your lordship. Here, the petitioner is praying to quash and set aside impugn speaking order dated 13 December 2019
Where is
at
that?
Annexure 6, page 39.
39.
Yes, lordship. Here, I was.
Why you are waiting till date?
Lordship. Lordship, we had filed a contempt petition earlier, and when
Contempt petition was disposed of when?
it was not disposed of, Lordship, it's still pending. But this honorable court had directed to file a writ petition challenging the speaking order.
Pardon, Miss
Upang nanalo.
Land Council petitioner, Mr.
Chingyangpong for Yang Urimal.
Yangabati, National Government Council for all the respondents. Assailing. A speaking order dated 13/12/2019. The petitioner has instituted a writ petition. By the speaking order. The respondent authority has decided to treat the intervening period from 15/5/2010 to 19/5/2015 as the petitioner's pensionable service. Post of it was further ordered that notional pay fixation benefits would be extended to the petitioner for a said period. Hence, the petitioner's pay after reinstatement into service with effect from 20/09/2015 has been is to be fixed notionally, and arrears, if any, would be processed for making payment for him. Agreed by the said speaking order of the petition. As opposed this petition notice returnable in 4 weeks, as Mr. Swenson, on behalf of Mr. Yangabati, Central Government Council has appeared and accepted notice on behalf of all the respondents, issues for formal notice to the site respondents, is dispensed with extra copies within 3 working days.
Obliged.
Number 1.
May I please, your lordship? My lord, I'm appearing for respond number 5, 6, and 7.
Yes.
My lord, I'm yet to receive instructions, so kindly allow me 3 weeks time.
To file your counter?
Yes, my lord.
Yes, madam.
Lordship, I have no objection.
Ms. So-and-so, the council for the petitioners is present, Mr. E. Tiba Hong. Government for the appearing for respond number?
5, 6, and 7.
You're there.
Therefore, responding 1 to 4.
And Mr. So-and-so, council on behalf of Mr. Yangabati, Central Government Council for the respond number 1 to 4 are present. Mr. E. Tiba Hong, Government of Nagaland. Appearing for respond number 5, 6, and 7. Has submitted that. But last opportunity
Yes, my lord.
has sought for further 3 weeks time as the last opportunity to obtain the necessary instruction and to file a counter affidavit on behalf of the state respondents. Okay. You want to file any rejoinder? The rejoinder, if any, to be submitted by the petitioner to the affidavit in opposition of the respondent 1 to 4 is also to be filed within 3 weeks time. Yes. The list the case, the prayer made by so-and-so is accepted, list the case after 3 weeks. by the 692 by the office.
Much obliged. For admission, item number 2.
May it please your lordship. Lordship, kindly grant me 2 weeks time to file my reply to the counter filed by the state lordship.
Okay. Miss Mika, HI, Learning Council for the petition has sought for and is granted 2 weeks time
Lordship.
to file an affidavit in reply to the affidavit in position filed by the state respondents. Miss AIME, Land Employment Advocate for the state respondent is present. List the case of the police on the date.
Much obliged, lordship.
For admission, item number 4.
Yes, Mr. Congener. Affidavit not filed.
Lordship,
You are.
I'm for respondent, Lordship, just.
Chief Secretary,
Lordship, 3 and 4, 2, 3 and 4, Lordship.
2, 3 and 4.
Lordship,
Okay. Mr. T. Congener, Learning Council for the petitioner. Mr.
Lordship.
Jamil. Jamil, I Jamil.
No.
Okay. Learning Council for, your government advocate? Government advocate for the,
You want to submit?
for number 1 and Miss Apila Santa.
standing counsel for respondent number 2, 3 and 4, Lordship.
Standing counsel, which department?
Department of Social Welfare.
Social Welfare Department. For the respond number 2, 3 and 4. This Social Welfare Department has to file the affidavit.
Lordship.
Okay. Ms. Sankam has sought for how much time?
Lordship, 3 weeks time. I have filed my wakalat number, but there are some errors.
Sought for and has granted 3 weeks time to file the counter affidavit on behalf of the respond number 2, 3 and 4. Raise the case after chiefs.
Lordship, on by the last order, I was to submit whether my father is getting pension or not. Family pension. The court wanted
This
to.
is the prayer here is for what? What is the relief you are seeking?
It is a compassionate appointment, Your Lordship.
Compassionate.
Appointment. No, the father is getting pension, Your Lordship. The father expired, but the mother is getting the family pension. This court wanted to determine whether it is a centrally sponsored scheme or not. But it is not. He was appointed as a normal driver under the department. While rendering service, he expired. The petitioner.
He was in a substantive post.
Yes, substantive
You want to
post.
say that?
Yes.
So the scheme of compassionate appointment.
Applies in my case
Right.
also. Yes, that is.
Lordship, the petitioner was appointed under CSS post. So records, I may be allowed to file my affidavit.
File it.
Lordship.
Yeah, allow him to. No.
You have anything to object in
Lordship.
affidavit?
Lordship, grateful Lordship.
For admission, item number 5.
Okay, your name is not there. Name of Miss Apila Sankam, Land Planning Council. Social Welfare Department is to be reflected in the respondents in the cause list. Yes.
Lordship, this is also regarding compassionate. Your Lordship may kindly go through the order dated 21/4/2026, Lordship.
Serial number
Okay.
68.
Lordship, I have received an instruction. Now the petitioner is in serial number 68. In the
60?
open, 68, Lordship.
Yes, what do you say?
Your Lordship, yes, there are sufficient vacancies and as per the scheme, Your Lordship, I should be considered. That is my only case.
Let them file an affidavit then. Already there is a direction. Already there is a direction. Earlier, in the earlier round, is
Yes.
it not?
In the earlier round, but what happened was without
To consider and dispose of the representation.
Yes.
That was not done.
that was not done. Then in the meantime,
You
this
said
came
that
out.
your name is at serial number 1.
Yes, under.
Now they say
Timap-
68.
Yes, under Dimapur district. Now there were more than 1,000 vacancies that came up. They conducted the interview. We were not even considered. Now out of that 1,000 something, 900 something appointment was given. Now there are more than 85 vacancies
1092
available.
means what? 1092 by a selection process.
By selection process.
You
and then-
participated.
No, Your Lordship, but then under the scheme, we have to be
So
considered
you are
against the certain
taking under
vacancies.
the scheme,
Yes,
not under true
no,
selection.
Your Lordship, because the scheme clearly
You
says,
you appear to be BCom candidate, BCom pass. You could have participated. You could have got the selection
Your Lordship, I
having
mean,
BCom qualification, but you are waiting for compassion.
Your Lordship, but the scheme is
Let them
very
file
clear.
affidavit. Or position, how you have got into 68 position.
Your Lordship, this may be the.
Consideration is not a
Yeah.
positive direction. To consider the representation is not a positive direction.
Your Lordship, yes, but under the scheme, there are specific percentage to be reserved for compassionate appointment. My
How much?
case is that
How much?
5%.
5%.
Now out of that 1,000 something, 5%, it comes to a,
Let him
Huge
give
amount.
the list 68. If your
yes,
position
Your Lordship.
is really 68, then he cannot be upgraded.
Lordship.
There are others in line. And how many vacancies are available?
Right now,
Yeah.
yes.
Let them say what are the vacancies under 5% quota for compassionate appointment and a list of candidates.
Your Lordship.
Let it be brought on record.
Your Lordship.
Then you can agitate the
So
issue.
Your Lordship, this, since they have already received the instruction, let it be the last. Yes,
Let him give the complete instruction
yes.
regarding the vacancies available under 5% quota for compassionate appointment
Lordship.
and a list
Yes.
maintained by you,
Lordship.
wherein this petitioner, his name has figured at 66.
68, Lordship.
But Mr. T. Congener Learned Counsel for the petitioner and Mr.
Jungli Lordship.
Ajungli, Learned Government Advocate for all the respondents. Posto. The state respondents are yet to file the counter affidavit. Post of Mr. Ajungli has submitted that he has received instruction to the effect that the petitioner's name is at serial number 58 in the list of candidates maintained by the department for appointment on compassionate ground. Post of para. As the petitioner is seeking his appointment on compassionate ground, the state respondent shall file its counter affidavit, wherein it should, wherein the position, present vacancy position under 5% quota for compassionate appointment, and the list maintained by the department, list of applicants maintained by the department who are seeking compassionate appointment are to be part of the said counter affidavit. For filing such counter affidavit, Mr. So-and-so Ajungli has sought for 3 weeks' time
Lordship.
to file the same. List the privilege allowed, list the case on so-and-so.
Lord.
Give it after 3 weeks.
Highly Lordship.
Orders, item number 17.
7.
Yes, Mr. Angami.
Lordship, I am praying for the state respondent 1, 2, and 3, Lordship, in this matter.
1, 2, and 3.
Yes.
My pleasure, Lordship. Lordship, by order dated 12/5,
1, 2,
2026.
Okay, 1, 2, 3. Then, what is the last date? Order?
12/5/26.
12/5/2000.
This honorable court has directed the petitioner to serve fresh notices.
So, in view of the 3 steps.
Yes, Lordship.
3
Accordingly, we have
steps directed.
yes, through speed post. We have
Yes.
served and we have annexed as
So,
annexure.
have you taken the steps?
Yes, we have filed this morning and I have in the affidavit. I think
Okay.
it has.
Affidavit filed by the petitioner regarding service of notice to the so-and-so through speed post. Enough.
Lordship, since the notice upon the respondent has been served, it may be considered to be completed. And in the meantime, allow us to file affidavit in reply to the affidavit in opposition filed by the state respondent.
Serving notice. So you have taken steps.
Yes, Lordship. Accordingly, we have enclosed with in the annexure as 1 to 5.
No, what do you have enclosed?
We have
That you
served
have
up to
taken
true-
steps.
Yeah, true speed post. We have served true speed.
That await service of notice.
Yes,
How can I accept that the service is affected?
Correct.
yes, Lordship.
Correct.
Heard, Mr.
Mary Bemo.
Council for the petition, Mr. Milani, government advocate for the respondent number 1, 2, and
3, my lord.
3. Full stop. Para. On. 12/6. On, sorry. On. 12/5/2026. The petitioners were directed to take brief steps for service of notice upon the respondent number 4, 5, 7, and 8
Yes.
by speed post. The petitioners, by filing an affidavit, have stated that the steps for service of notice upon the respondent number 4, 5, 7, and 8 have already been taken by speed post pursuant to the order dated 12/5/2026. Post of await for the service reports in respect of the respondent number 4, 5, 7, and 8. What about 6?
We have filed an affidavit. They have received.
They have received.
Yes, Lordship.
It is already there. Service steps not taking. Notice so and so private and files. Okay.
Lordship, the interim may continue.
The
There's no-
interim order passed earlier. Shall continue till until. Oh, okay. You have filed your affidavit, Mr. Nelson.
Yes, your lord. So I've already filed.
Okay. This is the case of the Chiefs.
I'll oblige.
I'm deeply obliged, my lord. For hearing, item number 8.
Although the petitioner was appointed by page 31, annexure 1.
31.
Yes. It is clerk's cum cashier dated 18/9/2007.
Nagaland Rural Bank.
My lord.
Uh,
My lord,
Okay. Clerk of Cashier.
yes. My lord, what I'm trying to bring to your lordship notice is what is this post? Is
Okay,
it?
let us see the documents, thereafter you can explain.
Okay.
Clerk can come cashier.
That is, what I'm trying to see is that is clerical in which is in the regulation it is given us.
No, we come to the merit later on. Let us see the facts.
My lord,
Then you explain what is clerk come cashier.
my lord,
Let us see the dates, sequence of events.
my lord.
Okay, this is 33, your appointment.
My lord, Oka. Under probation at Oka branch.
Go through the documents first.
My lord. Then,
Oka branch.
yes,
Okay.
then accordingly,
510 to
page
2007.
35.
That is Oka branch posting.
My lord.
Yes.
The
When you joined.
competent authority is the general manager in the case of
Huh? No, don't
assistant.
submit on merit.
My lord.
Let us have the facts first.
My lord. So accordingly,
This is your posting order, page 35.
this is my reporting to the competent authority.
Page 33 was the appointment order.
Yes.
Then this is your posting order, page 35. Proceed to Ukha branch, report to the branch manager, right?
My lord.
Then on 18-2000 to 2001 or 2007,
This is
you are joining, page 36.
2007.
7.
Yes.
Okay. You joined.
My lord.
At Ukha branch.
My lord.
Okay.
Then transfer 37
Good.
to Chipu Bazu.
Chiefo Bojo.
My lord.
Branch.
Yes.
Officiating officer. Branch in charge. 9/1/2016. Okay.
Then when
You joined.
My
You
lord.
joined.
Yes.
In joined and Sipo
Bazu.
Bojo branch. Okay. Thereafter what happened?
Then what happened?
We transfer. Again transfer.
Yes. Back to Oka.
Oka.
Yes.
Okay.
Then what happened is this. After the petitioner was transferred to Oka in release on 15. Yes. Release from there. What happened is this.
Suspension.
No, Malute, till my ending about the charge, there was no.
No, let us go through the documents first.
Yes.
Sir. You are making submission in between.
Malute.
The sequence. I've been looking at the brief for the first time. So first I have to understand how the events proceeded. Right? Yes. Page 39. You have been suspended.
Malute. My paragraph 5. What happened?
No. Let us see the documents. Thereafter I'll see the pleading.
Yes.
Come to the documents, sir.
Malute.
Let us go serially. I have reached 39.
So 17/8/2017.
Come to page 37. So you've been suspended.
Subsequently,
17.8. I look at your pleading, sir. Let me understand first. 17.9, 17.8.
seventeen A, that is, order is passed by the chairman. That is what I'm trying to impress upon your lordship.
What is your explanation?
Also,
You have the memorandum of charge?
that's, it start from 67. So, my lord, page 70,
I have seen.
last part. On this particular date, 17/8/2017.
No, I have seen entire thing, 68 onwards.
Yes,
What you said, response, Mr. So-and-so's account has since been regularized by me.
my lord, I accept that. I'm not arguing on that. This is the reply.
This
So I
is
cannot
this is the
reply.
reply. This is the reply. And make submission because you are either a cashier or clerk or an officiating manager of a bank.
No, I understand. Yes.
Now, all these have been admitted in your reply statement,
My lord.
right?
My lord.
Let me go through the documents then.
Then departmental inquiry, page 71. 1/2 of 2018.
I have looked at page
Yes.
73. Page 73.
Not what I'm trying to impress upon your lordship is the chairman. That is what I'm impressing.
Let me go through it.
My lord.
I am saying that I am looking at this document for the first time. At least I should have knowledge.
Lord.
Give me that opportunity.
My lord.
I'll give you the opportunity. Did you file any appeal?
No. Then
Did you file any appeal?
yes.
Where is the appellate order?
It should be the chairman, my lord.
No. You are again making submission on maid. Where is the appellate order? I have asked for an appellate order.
No.
Please have that patience.
My lord. I apologize.
I asked for where is the appellate order?
114.
One,
114.
114. So appellate authority rejected the appeal on the ground of delay.
My lord.
Okay. Now you tell me, on what ground the order of the disciplinary authority is challenged? On what ground?
My lord, what happened is this. I was not furnished with the inquiry proceeding report. So I have to apply to the BIO of the fish concern. Was not furnished.
Who is that you have said?
RTA, sir. Page 91, my lord.
What is the order of punishment, imposition of penalty? Page 90 is the point.
90, my lord.
When you were furnished with the inquiry report,
After I file it before the State Information Commission only. There is no order from the commission, but after I file it was furnished to me.
when
That's it.
to the information
What?
commission,
101, my lord. One,
uh, where is it? That's true.
101 in 2, my lord. Received Jawasa. Received by you. received it. Cháu yêu nhiều. My lord,
Non-particular. 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 Yes.
in my appeal, it is stated it page 98. How the sequence happened.
In 98.
My lord, para 6.
So you finally received it.
Yes.
You finally received it as disclosed by the authority on 2/8/2019,
My lord.
right? Where is the appellate order? At, you said
114.
114. 7/3/2022. So whether you have a right to receive the inquiry report.
Yes.
Ah.
At least I should be furnished with that.
Where is the bank regulations?
Bank regulation starts from 120, my lord.
Penalty.
Disciplinary proceedings of punishments.
Now, in the rule, which rule provides for supply of the inquiry report?
Rule 39 speaks about the penalties. The petitioner will come under Kohima 39 to 39 to right. It will be under the employees. One is minor, B is major.
Where is the provision regarding inquiry report? Otherwise, see, Mr., you have admitted everything.
No.
You were a
That
bank
I'm not-
official.
I'm not.
Bank official,
Yes,
right?
right.
And even for, Supreme Court has said even for 50 rupees, a cashier or clerk or bank manager
No.
misappropriates, dismissal is justified.
No.
Lots of,
Understand your loss.
lots of decision, and you have
Yes.
clearly admitted everything. There is nothing for imagination.
No,
Right.
what
Now, what are the grounds?
I'm saying
What
is,
prejudice is after you have admitted, but they still proceeded, right?
no,
With the inquiry. Otherwise, they have a provision in the bank regulation to straight away after admission, see the provision. Just for a moment. They have been consistent with the principles of natural justice in the sense that despite your admission, come to page 130.
yes,
Come to 130 4 onwards. 135. No inquiry shall be made.
not necessary.
If the misconduct, C. The officer makes a voluntary admission of his guilt in his reply to the show cause notice.
Malo, what happened in this case?
It is not a single amount, so many amount. Even if suppose, if you replenish, something has been taken out. Again, you have get the amount deposited in the account. That is also said.
Yes.
Misappropriation is proved. If you deposit the amount in the account again. So it is not a single instance, about 50 instances.
Malo,
So on what done you are?
what I'm saying is this. Under Regulation 38, I should abide by whatever order my superior give. So on 17.8,
What?
on 17.8, I was called up by the chairman and the chief inspector. Then verbally I was directed. Look, there are some discrepancies. You have to deposit it within
You could have walked out.
1 week.
You could have,
20
you could have walked out. If you are an experienced bank employee, you could have walked out. Chairman could have suspended you, could have drawn disciplinary proceeding against you, but he cannot force you. If you have succumbed to the pressure of the chairman, it was up to you.
Malo, what I'm stating
You
is
should not have
this.
succumbed. You should not have succumbed if he had made some illegal direction to deposit.
Malo, I'm not saying that
But from your response after that, after the memorandum of charge, you have been suspended.
yes,
You are out of hands of the chairman. You were sitting at home. When the memorandum of charge was supplied to you, you have admitted again fully.
Malo,
And money, and one thing which chairman could not have done, you pocketed the money yourself in your account.
My lord,
What more is required?
what?
In a case of this nature, what substantive justice is required to the
My
petitioner?
lord, what I am saying is this.
If the chairman is a higher authority than your appointing authority, there is no bar
No
in
bar.
law.
No.
And it is not a case of that you have lost an appellate authority. Board of Directors was the appellate authority. You have not lost any forum. That, I don't think so, it is a ground. And after your admission, what more is required?
My lord,
What more is required?
my lord, what I'm saying is this.
Let us come. Now I have seen the documents. Now you say what the chairman has terminated you.
My lord,
That is your ground, removal.
no. My statement may be seen in para 5 of
Okay.
my.
Okay, now I'll see.
On 17/8/2017, the petitioner was called up by the chairman, the then chairman, Sir Sergeant Sergeant Chief Inspector Mr. Sergeant Sarge to the head office, Kohima, and informed that there was a discrepancy of so much amount, and the petitioner was directed to replenish the said amount within 1 week. That is, on or before 25/8/2017. Accordingly, the petitioner complied with the direction and order by the replenishing the such and such amount within the directed and stipulated time period. Furthermore, till the stipulated time of 1 week, the petitioner was directed not to attend the office. Yes. That regulation 18.
Which they have denied, except to the extent they have said in paragraph 8. We are in writ petition. We are not in the criminal trial or civil trial.
No.
That has been denied
So,
in the affidavit in opposition.
affidavit in opposition,
Paragraph
he
8, I have looked at.
did not directly deny
Only,
the
no,
fact.
admitted to the extent borne by records. And they said committed about the offense of misappropriation of money, not only one occasion, several occasions. And the petitioner never denied the allegation and had been replenishing the misappropriated money without any contention. Criminal intent, premeditated motive, intention. So your contention is objected. So it is not a fact admitted, paragraph 5. Otherwise, what are your case? Your case is admission of many things. A bank manager who is supposed to be the guardian of public money
Well,
involved himself in, and when the fear of being caught,
no,
otherwise why you are replenishing the money?
it's not fear. I was caught.
Oh, you are good manager.
That
But
is why
anyway-
I admitted to overload.
Anyway, your reply that is not under pressure cannot be said to be under pressure. Your this thing, why you have annexed all those document, debit, credit? Come to page 68. Page 68. That is not bank document.
My admission.
That is your admission.
My lord.
Page 68, 69, 70. That is enough. And what more contention?
My lord,
Paragraph 5 I have seen.
what I've stated is this, my lord, last part.
Their reply is also seen.
My lord,
And what other ground?
what I'm bring to your lordship is that as the chairman in the chief inspector directed me to do a certain thing at a certain point
Yeah,
of time, I've done.
We were not in the room, neither she. Then it is a case of read petition. You made a pleading. It has been clearly denied. These are facts disputed. But what are the facts admitted? What are the facts admitted? This fact admitted are sufficient.
Admitted fact.
Yes. These are sufficient enough
Mano,
that you are lucky that you have been removed,
otherwise,
not
should
dismissed, and no criminal case has been lodged just because you have replenished the money.
within this stipulated
That which
time.
did not
Right.
cause monetary loss somehow, fortunately, to the bank, perhaps. And you are fortunate to have a penalty of removal. What is what is the order of removal? That's penalty.
9-0.
90. Let us see 39 2B5. 39 2B5. Thirty-nine. Two. 39 2. 39. Get 39. Officer. Employee. B.
133.
Ah.
130.
You are so fortunate. Page 136. Removal from service which shall not be a disqualification for future. Bank has treated you leniently for the level of misconduct. Not a disqualification. They did not impose dismissal.
By now, even
That is
employee very
still
low.
no stigma is attached. No stigma is attached to it. Yes, madam. Any other ground? Any other ground?
No. What time?
I could understand.
Yes.
I thought it over. I thought it over regarding your inquiry report, non-supply.
Yes.
But that is to be considered what you had admitted. Otherwise, I could have entered into that non-submission of the inquiry. But you have admitted everything. And it is not that you have been not provided with the opportunity to take part in the disciplinary proceeding. You participated, you give answers to the inquiry officer wherein your answer is there and you have signed below.
Not denied. I'm not
Not denied.
No.
Not denied. I tried to find out something, if something is available, that you have not denied. You repeated before the inquiry officer, repeated the same thing. Had you denied, then the situation would have been different. But you admitted all along that these all are, you have managed by regularizing the accounts. And something you have already also admitted that money was taken to your account also. That is something for a bank manager. Law is settled. Yes, any decision? Bank manager.
Your lordship,
No mobile. I thought it over regarding non-supply of inquiry report. But whether any prejudice has been caused from that angle, right? But no prejudice for a read court to enter into. Yes, madam.
your lordship, all the
statement has been, as this honorable court suggests, all the allegation has been proved against the accused, and the accused himself has admitted in his letter also to the department. And this is not the first instance where he has misappropriated with the money. When he was posted in Oka, also I have annexed in my reply also. Same thing, even though, yes, Your Lordship, we are not into that, but the bank has shown him leniency, and now in the present case, proper investigation has been done. And we have given him, as Your Lordship has already pointed out,
Just. Whatever was in the memorandum of charge,
yes,
we'll
It's-
consider that only. We'll not
yes,
consider
yes, Your Lordship.
wherever he had done
no.
other misconduct. We are not into it because that was not the subject matter
Yes,
of
yes, Your
inquiry.
Lordship. So
Right.
all the allegations are proved.
Ah.
Proper procedure has been done during the investigation.
But you have not provided him the inquiry.
Yes, Your Lordship. In the
After
first
much
instance-
persuasion, you have.
No, in the first instance, we have not given him while giving the termination order. Termination order. Later on, when the petitioner filed for the inquiry report, the letter which they have given is they have asked for dismissal order, not termination order. The wording itself
Hey,
is
you could have
different.
still given it. I have seen
No,
it, madam.
yes,
You could have still given it. You are very so technical.
that is the bank procedures. Your Lordship.
That I don't know. This disconduct of the bank
Yes,
is
Your
not
Lordship. I know, I know.
good. That is not good.
That's true.
That you are not dismissed, you are removed. So you have asked for dismissal order, we will not give you. What is this?
So after three.
He has a right, madam,
Yes.
under the
definitely.
ECIL decision or Supreme Court. He has a right to get the copy of the inquiry report.
Yes, Your Lordship. So,
And you have taken some plea,
yes, Your Lordship.
all this bogus plea, not the dismissal, removal. What is this? And you have denied him up to August 2019.
Your Lordship, after that, we have written the letter. So he filed the first appeal after 3 months, Your Lordship. So within 2, 3
That is also a technical error.
within 2-3 days, we have already sent him the inquiry come report. But again, he has waited another 3 months. And during this period, more than 6-7 months has been wasted, Your Lordship. And he has filed the statutory appeal. Yes, Your Lordship, it was the fault of the bank not to give the inquiry come
Yes,
report
you
on the
see
first place.
your conduct. That is also not appreciated. Come to page 100. This removal order was at page 80 or something.
990.
90. 90. 90. That was on 7/2/2019.
Yes, Your Lordship.
Now see your explanation to the Nagaland Information Commission that he asked for dismissal order.
Yes, Your Lordship. I
You
know.
don't understand what he was meaning thereby. You denied him the inquiry report because he had to file the appeal
Yes.
in time as per your what is the time period for appeals?
45 days. Your Lordship.
45 days. But that was not supplied to him, the inquiry report, which was constitutionally should be made available. It is his constitutional right. That was not. Then you supplied him after he approached Information Commission, 2/8/2019. Right?
Yes, Your Lordship.
You have admitted so. Then who is the inquiry report? This is the inquiry report, page 105.
Yes, Your Lordship.
My inquiry report. Then the appellate order. Two eight 2019. 2/8 2019, if you count 45 days from that, 2/8 2019. And he filed it 29/11/2019. August, September, October. Barred by time, still barred by time. Mr. If you have received, I examined it. If you have received the inquiry report on 2/8 2019, thereafter you file a bill on 29/11/2019, it is still barred by time. It is still barred by time.
Was received on
I'll resume after 5 minutes.
Thanks.
Yes. For list. Yes. I'll come after 5 minutes. 5 minutes.
Was that RTA applications issue?
Mr. Longshar, your ground is chairman initiated. Paragraph 5.
Madam.
And inquiry report they were furnished at the time of order of penalty, subsequently submitted. Subsequently furnished to you.
My lord, that is on, yes.
One more ground.
2/12 of 09, my lord. Receipt date is given in my receipt. Para
Para
15 of my petition.
Petition. They said on 2/8/2019.
So the receipt date is given in page 105.
105.
Yes, this is petitioner signature 10/12 of 2019.
105.
This is after he approached the State Information Commission. This is by the 103 is by the inquiry officer. 103.
Inquiry report was dated
the disciplinary authority
2018. 3/9/2018.
And
you received it on
2/12/2019. To 10/12.
What?
Yes.
In view of your admission, what is the contention? In view of your clear admission,
Hello.
how you are prejudiced after you admitted everything, not only in your parawise comment and during the inquiry proceeding also, you admitted clearly that all I have done. So what kind of violation of principles of natural justice? Because prejudice is to be pleaded. What prejudice? In view of clear admission. Otherwise, court is always conscious that principles of natural justice should not be violated. But it is not always, it is applicable straight away. Court is to look into what kind of prejudice has been caused by non-furnishing of the inquiry report. But here is a case where clear admission on the part of the petitioner. So we don't find any prejudice. SCC election of me. SCC election. SCC is night. SCC online night of me. 89. Password to KC. 97. Now, in 2008, 2008, 9 SSC, 31. 2008, 9 SSC, 31. Rata, 2010, 3 SSC, 556. Grameen Bank also, same inquiry.
May I pray your lordship may kindly look into my petition page 40. 40. The other two have not been, I've replenished. Otherwise, you are therefore hereby advised. May I read out, my lord?
Hmm.
Such and such. dated 14/9/2017, which refers to the caption, you've deposited such and such on such and such as such and such towards adjustment of his account from where you have misappropriated that money. Yes. During further scrutiny of such and such, it come to light that you have misappropriated rupees 4,000.
7,700.
Yes,
I have seen.
yes.
I've seen.
In
But your admission has damaged your case. Your admission has damaged your case.
Malo.
Even if 25 rupees misappropriation is misappropriation for a bank manager or bank officer, bank clerk, law is settled.
Malo.
You must be aware of it. An inquiry officer report that is also has been settled because no prejudice, because of your admission, clear admission.
Much obliged.
In this repetition. Instituted under Article 226 of the Constitution of India, the petitioner has sought setting aside, has mainly sought setting aside and passing of an order dated 7/2/2019, passed by the chairman as the disciplinary authority, whereby the petitioner was imposed the penalty of removal from service in terms of Regulation 39 within bracket 2 within bracket small b within bracket small Roman 5 of the Nagaland Rural Bank within bracket officers and employees bracket close service regulations, 2010 within bracket the bank regulation, NRB regulation or short bracket close with immediate effect. Post up. Apart from the state main relief, he has sought a number of other reliefs in the writ petition. Post up. Para. The Nagaland Rural Bank was established on 30/03/1983. Please hear me out. If something factually I go wrong, please correct it. Under the rural, just a wait. This one. That one. That one will do. That one will do. The one on the top. Give me that. File over Rural Banks Act 1975. Which is jointly owned by the Government of India, Government of Nagaland, and the State Bank of India. Full stop. Para. Pursuant to a selection process conducted on 31/7/2007, the petitioner came to be selected for appointment in a post of clerk cum cashier in the NRB, by an order dated 18/9/2017, the petitioner was offered appointment in the post of clerk cum cashier in the prescribed pay scale with effect from the date of his joining. Full stop. The appointment order mentioned that the appointment would be governed by the regulation, NRB regulation. Full stop. The petitioner was directed to report at the head office of the NRB on 5/10/2007 for observing necessary formalities. Full stop. On receipt of the appointment order, the petitioner accordingly joined in the post of clerk cum cashier in the NRB, full stop, by an order dated 5/10/2007, the petitioner was posted to Okha branch on probation, and he was directed to report to the branch manager there for duty. Full stop. Accordingly, the petitioner joined at the Okha branch by submitting a joining report dated 8/10/2007. Full stop. When the petitioner was serving in the at the Okha branch, he was transferred to CHIEPHOBOZOU, page 37%, branch as officiating officer and branch in charge, WEF 9/1/2016, by an order dated 5/1/2016. Full stop. By the transfer order, the petitioner was directed to take over complete charge of CHIEPHOBOZOU branch on 9/1/2016. Full stop. Subsequently, on 14/7/2017, the petitioner was transferred and posted to Okha branch again as officiating officer.
Office assistant, Manu. This is office assistant. Petitioner,
who was serving as office assistant MP, to the Okha branch again as officiating officer WEF 17/7/2017. Para.
This is office assistant, not officiating. Chief was he was officiating.
Sir,
Yes.
page, I have only dictated from the order. I have said who was serving as office assistant MP. As officiating officer, it is there written. I am not coining my own words. It is there, officiating officer. Page 38, please see. Please see. Page 38, sir. Or page 38A. So don't read, unless you have a valid reason, don't disturb. By an office order, subsequently by an office order dated 17/8/2017, the chairman cum disciplinary authority placed the petitioner under suspension with immediate effect, i.e. 17/8/2017, for violation of regulation 18 and regulation 20 of the NRB regulation. Poster. In the office order, it was mentioned that it had come to the notice that certain irregularities of serious nature was allegedly committed by the petitioner at CA Pojo branch while the petitioner was posted there. Poster. The suspension order was stated to have been passed pending detailed investigation followed by inquiry into the alleged irregularities committed by the petitioner. Poster. The petitioner was made entitled to subsistence allowance in terms of the NRB regulation. Poster. Para. On 14/9/2017, the disciplinary authority wrote to the petitioner that the petitioner had deposited page 40, 44,700 এখানে এনেকে লিখিব লিখি you have what height the petitioner করে দিব কই যাম বাৰু আপুনি চাই ল'ব তাৰ on 7/8/2017 and rupees 6,300 on 16/8/2017 towards credit of account number so-and-so of 13YHO-U and also 3,57,513 on 25/8/2017 towards adjustment of office account wherefrom he had misappropriated the money during further scrutiny of vouchers stroke documents on 28/8/2017. It had come to light that the petitioner had also misappropriated rupees 7,700 from 3 accounts in the following manner. 1 to 3. By the Letter dated 49/2017, the petitioner was advised to replenish the amount of rupees 7,700 immediately within 7 days on receipt of the letter, failing which the bank might initiate necessary action as deemed fit. In response to the letter dated 14/9/2017, the petitioner by a letter dated 3/10/2017 mentioned that there was no misappropriation in case of account number so and so of Sri Ashraf Ansari. Full stop. The particular transaction of rupees 400 on 7/12/2016 was done to facilitate the customer in withdrawal of fund by way of transfer, as he had already used up his limit of rupees 24,000 per week. The petitioner requested to verify the same and to exempt him from repaying the amount which had already been given to the customer on the specified date without any element of misappropriation. Post stop. Para. The petitioner was served with a charge sheet on 15/11/2017 on the ground that during his tenure as branch manager at Sipe Bojo branch, certain serious lapses / irregularities were committed by him in connection with misuse of customers as well as office accounts and misappropriation thereat in a fraudulent manner. Page 42. It has been informed that a decision was taken to initiate disciplinary proceedings against him in accordance with the provisions of the NRB regulation, which were applicable to the petitioner. Full stop. A statement of articles of charge, a statement of allegations showing imputation of lapses and a list of documents related to the allegations and to be relied upon during the course of proceedings were furnished to the petitioner along with the charge. The petitioner was asked to submit his written statement of defense in terms of Regulation 39 of the NRB Regulation 200, NRB Regulation, in response to the charges alleged against him within a period of 15 days. Post. By the three allegations mentioned in the statement of imputation of lapses were as under paragraph page 44. Itu matum. The photocopies of the related vouchers and other documents were also supplied to the petitioner along with the charge sheet. In response to the charge sheet, the petitioner submitted his reply on 14/1/2018 with an apology for on 14/8/2018. The reply given by the petitioner in response to the charge sheet would be adverted to in the later part of the order. Full stop. By an order dated 1/2/2018, the disciplinary authority directed for holding a departmental inquiry into the allegations stroke charges against the petitioner and had appointed an inquiry officer and a presenting officer in terms of Regulation 39 and Regulation 41 of the NRB regulation. First up, the petitioner was informed that he would be given a fair and reasonable opportunity to produce his defense by oral and documentary evidence relevant to the charges in terms of the provisions of Regulation 39 of the regulation. The petitioner was also permitted to be defended by another staff of the bank as his defense representative. Full stop. Thereafter, the disciplinary proceeding or departmental inquiry started with the preliminary hearing on 14/6/2018, wherein the inquiry officer, the presenting officer, and the petitioner as the charge sheeted employee, EO, PO, and CSC were present. On the said date, the preliminary PO presented the case before the EO by reading the charges of allegation against the petitioner. The EO permitted the petitioner within CSC to go through all the documents exhibited and to give his comments if he wished to. First of the EO asked the petitioner CSC whether he would accept the charges leveled against him or he had any documentary proof stroke evidence to deny the charges. In response, the petitioner CSC gave a reply, which should be adverted to also in the later part of the order. So the disciplinary proceeding, regular hearing, had thereafter proceeded on different dates, 3/7/2018 and 7/8/2018, wherein the petitioner, wherein the inquiry officer, wherein the presenting officer and the petitioner as petitioner CSC participated. First of all. After conclusion, the regular hearing concluded on 7/8/2018 with a direction to the PO to submit his brief report with a copy to the petitioner CAC. So the petitioner was directed to submit his brief upon receipt of a report from the PO, trailing which the EO would submit the matter to the disciplinary authority. The EO, PO had thereafter submitted a brief report on the departmental inquiry against the petitioner, CAC, on 13/8/2018 with a copy to the petitioner. Para. The EO had thereafter submitted an inquiry report dated 3/9/2018 before the disciplinary authority. The disciplinary authority, after having examined the charge sheet, submission or reply of the petitioner dated 14/1/2018, proceedings of preliminary hearing and regular hearing, and a brief report of proceedings of the PO and the petitioner's CAC brief reports on proceedings dated 3/7/2018 and 7/8/2018 from the PO, and reports dated 13/8/2018 and 25/8/2018 submitted by the petitioner CAC, and the inquiry report dated 3/9/2018. Imposed the order of penalty of removal from service in terms of Regulation 39 within bracket 2 within bracket small b within bracket small Roman 5 of the regulation, NRV regulation, with immediate effect. Postal. The order of penalty further mentioned that the period during which the petitioner was placed under suspension would be treated as, quote, period not spent on duty, unquote. And further recovery to the extent of his outstanding dues stroke loans to the bank would be made from his terminal benefits, VIJ, Provident Fund, stroke, gratuity, etc., following extent guidelines. The order of penalty further mentioned that if the petitioner, CAC, would desire to file an appeal against the order of penalty, he may submit the appeal in writing within 45 days of receipt of the order to the appellate authority, and the board of directors of the bank would be the appellate authority in terms of Regulation 50 within bracket small Roman 1 of the NRV regulation. The order penalty dated 7/2/2019 was duly served upon the petition. During the subsequent period, the petitioner wrote to the authorities in the NRB for a copy of the inquiry report submitted by the youth on 3/9/2018 on the ground that a copy of the same was not furnished to the petitioner at the time of imposition of the order penalty. Full stop. As the petitioner's request for the copy of the inquiry report was not acceded to, appeared to have not been acceded to by the respondent authorities in the NRB. The petitioner, while approaching the authority, while approaching the Nagaland Information Commissions, had also preferred an appeal before the appellate authority, i.e., the Board of Directors, NRB, on 29/11/2019. Full stop. The appellate authority after consideration of the appeal dated 29/11/2019 informed the petitioner on 7/3/2020 that the appeal was presented beyond the stipulated period of 45 days, and there was a delay of 290 days. Fair. In the above backdrop, the petition has approached this court by the present petition. Firstly, I have heard Mr. I.M.P. Lonchar, learned counsel for the petitioner, Ms. Learned
Respondent number 2.
respondent for the respondent number 2, bank. 1, Mr. E. Thiba Phong, learned government advocate for the respondent number 1. First of Mr. Lonchar, learned counsel for the petition, has submitted that there was an element of coercion exercised by the disciplinary authority in that on 17/8/2017, the petitioner was called by the disciplinary authority at the head office of the bank at Kohima and informed him that there was discrepancy amounting to rupees 3,57,513. By informing him so, the petitioner was directed to replenish the said amount within a period of 1 week. And in view of such direction, the petitioner complied with such order by replenishing the whole amount of rupees 3,57,513 on 25/8/2017. Mr. Longshore has further submitted that as per NRB regulation, for an employee like the petitioner who was serving in the substantive post of cashier, clerk cum cashier, and was only officiating as branch in charge. The NRB, it was the general manager who was the disciplinary authority, not the chairman of the bank, as per which regulation? Regulation
Regulation 2.
where is that? You said in your writ petition, is it not?
Definitions.
No, not definition. The particular regulation.
Page 120 is 2. And
Where is your statement in the writ petition? Regulation 18 and regulation 20. Is it so?
page 6 of the petition. Para 3.
Page 6.
Yes, ma'am.
Justin. Page 6 or page 6.
My lord.
As per regulation 2 within bracket 1 within bracket small b, read with regulation 5 within bracket 1. Of the NRB regulation. First of it is his contention that as per regulation 15, the chairman was the appellate authority. First of it is his further contention that the enquiry report of the enquiry officer dated T9/2018 ought to have been supplied to the petitioner along with the order of penalty dated 7/2019, but the enquiry report was a copy of the enquiry report was furnished to the petitioner belatedly on 10/12/2019, and the same was an act in violation of the principles of natural justice. Yes, these three. Anything? Ms. So-and-so, learned counsel appearing for the respondent number 2 has submitted that the allegation of coercion has been wrongly made, and the said allegation has been clearly denied by the respondent bank in the counter filed poster. The allegation of presence of any element of coercion is a misconceived one. Poster. It is further submitted that in the reply to the search sheet, the petitioner had clearly admitted as regards misappropriation, and in the course of post-op, the petitioner had duly participated in the departmental inquiry and there was no allegation that the petitioner was not provided a proper and reasonable opportunity of being heard. Full stop. When the inquiry officer asked after allowing the petitioner to go through all the documents exhibited by the PO, asked his comments as regards the charges leveled on him, the petitioner had clearly admitted charges. Full stop. The petitioner was serving as a clerk cum cashier and was also officiating as branch in charge during the relevant time at Sopohe so-and-so branch, Bajau branch, wherein the illegalities had occurred. So being the branch in charge, at the relevant time, the petitioner was had clearly committed misconduct. And the misconduct is grave in view of the fact that certain amounts, the petitioner had got credited certain amounts to his own bank account. Full stop. As regards supply of the inquiry report to the petitioner belatedly, Ms. So-and-so has submitted that in view of clear admission of guilt on the part of the petitioner, there is no prejudice caused to him for non-supply of the inquiry report at the time of the order, at the time the order penalty was passed. It is on the point regarding the I'm referring to Regulation 5(1) of the NRB regulation. It is submitted that the chairman can act as the disciplinary authority and at the relevant time, there was no general manager to act as the appointing authority. Post of. I have duly considered the submissions of the Land Council for the parties and have gone through the materials brought on record by the parties through their pleadings. I have also perused the provisions. I have also gone through the provisions of the Nagaland Rural Bank within bracket officers and employees bracket close service regulations, 2010 within bracket NRB regulation, which was published in dated which was framed with the previous sanction of the central government and notified in the Gazette of India. Postal. We'll resume at 1 o'clock. As per regulation 2 within bracket small g of the NRB regulation, quote unquote, competent authority means the chairman, in respect of officer, and the general manager, in respect of employee. As per proviso to regulation 2G, if there is no general manager, the chairman shall be the competent authority in respect of employee. Full stop. Classification of officers and employees has been provided in Regulation 3. Post of as per Regulation 5 within bracket 1, the chairman shall be the appointing authority in respect of officer, and the general manager shall be the appointing authority in respect of employees. Provided that if there is no incumbent to the post of general manager, the chairman shall be the appointing authority in respect of employee also. Full stop. It is a categorical stand of the respondent number 2 that at the time when the petition was suspended, the general manager post was vacant, and it is the chairman of the bank who had suspended the petitioner by the order of suspension dated 17/8/2017, and thereafter Commander charge sheet was submitted by the chairman in the capacity of the appointing authority, come disciplinary authority on 15/11/2017 as the petitioner at the said point of time, was serving in the post of office assistant multi-purpose in the substantive capacity and in the post of branch in charge in the officiating capacity, first at the Okha branch and subsequently at CFO Bojo branch, in respect of which the allegation of misappropriation was brought against the petitioner. Post of in view of the regulation mentioned in above, this court has no reason to make interference to the either to the charge sheet or to the order of penalty taken issued under the hand of the chairman of the bank in the capacity of disciplinary authority, come appointing authority in respect of an employee in respect of the petitioner in the absence of any general manager in the bank. Post of. But insofar as the contention made regarding element of coercion exerted upon the petitioner by the chairman on 17/8/2017 by asking the petitioner to attend the head office is concerned, the respondent bank has categorically has refuted such allegation in its affidavit in opposition. Post of. The petitioner after 7/8/2017, the petitioner is found to have responded to the letter dated 14/9/2017 on 3/10/2017 without raising any kind of objection, save and except clarifying that the allegation regarding misappropriation in case of in respect of the in respect of the transaction in the bank account of Ashraf Ansari so the petitioner stated that as the transaction in connection with the bank account of Ashraf Ansari was done to facilitate the customer in withdrawal of fund, he should be exempted from repaying the said amount of rupees, the concerned amount of rupees 4,000. Subsequently, when the petitioner was served with the charge sheet, along with a statement of articles of charges and statement of allegation showing imputation of lapses, the petitioner did not refer to any incident of pressure being exerted upon him. So rather, the petitioner is found to have responded to the allegations of misappropriation by way of admission only, to the extent which should be mentioned here in below. So stop. A petitioner had thereafter participated in the preliminary hearing stage and the regular hearing stage of the departmental inquiry. Full stop. The petitioner was allowed to take the assistance of another staff as his defense representative by the letter dated 1/2/2018, whereby the disciplinary authority had ordered for holding a departmental inquiry into the allegations charges against the petitioner, with the appointment of presenting officer or inquiry officer and presenting officer. First. In such obtaining facilitation, the element contention as regard the allegation as regards exertion of pressure, exertion of coercion from the disciplinary authority appellant authority is found misconceived. What's the para? When the petitioner was served with the charge sheet along with the statement of allegations, articles of charges, and the statement of allegations showing imputation of lapses, committed by him, comma, the petitioner was informed about the nature of activities relating to his act of misappropriation in connection with the accounts of the customers of the bank in contravention of the bank's procedure, resulting in damage to the bank's image and reputation, and the amounts involved in such transactions with the dates on which such acts were allegedly committed by the petitioner, comma, the petitioner is found to have responded on 14/1/2018 in the following manner. Page 68 A to A. Again, during the preliminary hearing, held on 15/6/2018, when the inquiry officer, after allowing the petitioner to go through all the documents exhibited by the PO, invited the petitioner's comments if he wished to do so, the petitioner responded in the following manner. Page 73. It is the order of penalty of removal from service was passed on 7/2/2019. The order of penalty was in terms of regulation 39 2 within bracket B within bracket Roman 5, which is removal from service, which shall not be a disqualification for future employment. It is one of the major penalties in terms of the MRB regulation. Which can be imposed upon an employee of the bank. Regulation 49 of the regulation has provided a right to an officer stroke employee of the bank to prefer an appeal. An appeal against any order passed under the regulation lies to the appellate authority mentioned in Regulation 50 within a period of 45 days from the date of receipt of such order. As per Regulation 50, an appeal lies before Roman 1, the board, where the chairman is the competent authority, semicolon, and two, the chairman where any other officer is the competent authority. Full stop. Para. The order of penalty in the case of the petitioner was passed on 7 to 2019. Full stop. From the materials on record, and it is an admitted position it is an admitted position that the inquiry report dated T9 2018 of the inquiry officer, which was considered by the disciplinary authority come appointing authority in passing the order of penalty on 7 to 2019, was not supplied to the petitioner with the order when the order of penalty was communicated. Post up. The petitioner was found applying for a copy of the said inquiry report to the bank authorities in the subsequent period. And finally, he approached the Nagaland Information Commission. So before the Nagaland Information Commission, it was submitted by the respondent bank that a copy of the inquiry report dated 3/9/2018 of the inquiry officer was sent to the petitioner by speed post on 2/8/2019. On the other hand, it is the case of the petitioner that he acknowledged the receipt of a copy of the inquiry report of the inquiry officer on 10/12/2019. Thus, it transfers that the copy of the inquiry report was received by the petitioner belatedly on belatedly, full stop. Even it is accepted, assume that the petitioner had received the copy of the inquiry report on 10/12/2019. Whether the same had amounted to violation of the principles of natural justice. Full stop. there is no denial to the fact that the petitioner had admitted about the commission and omission committed by him in respect of the transactions in the bank accounts of the customers and the office account of the bank in a manner alleged by his admission in a reply to the charge sheet, as well as before the inquiry officer at the stage of preliminary hearing on (15/6/2018), post of the proceedings of preliminary hearing and the regular hearing of the department inquiry were drawn up under the signatures of the inquiry officer, the presenting officer, and the petitioner as the charge-sheeted employee. The version given by the petition at those stages have never been denied by the petitioner at any subsequent stage by way of retraction. Post. It has been observed by the Honorable Supreme Court in B.M. Sastry versus Karnataka Vikas Gramina Bank, 2023, 18 SCC 197, to the effect that the bank officers are required to exercise and follow the highest standards as they are dealing with money deposits by their customers on faith of the bank. Therefore, the duties as discharged by the officers of the bank are required to be performed with utmost devotion and diligence for reposing trust on the bank, otherwise it is unbecoming of an officer. The allegation against the appellant therein was to the effect that while he was working as an officer of a regional rural bank constituted under the Rural Banks Act, he was not supervising the work of his subordinate clerk who committed fraud in the bank and misappropriation of funds of the bank, causing loss to the bank. The charges were found proved and penalty of dismissal was imposed against the appellant. Full stop. The Honorable Court had found that and observed and perusal of the allegations leveled against the appellant, it was apparent that he had not verified the genuineness of the debits of interest on deposit, comma, semicolon, he did not verify. Did not notice non-genuine stroke fraudulent transactions, semicolon, did not verify or notice the fraudulent unauthorized alterations, comma, in taking of the amounts, comma, failed to check, stroke verify vouchers, etc. And as a result, there were fraudulent reduction and defalcation of the balance under interest account and diversion of funds, etc. Having found that the appellant had felicitated his subordinate clerk to commit such fraud, resulting in misappropriation of money, the Honorable Supreme Court did not find any perversity in the impugned order of dismissal. Penalty of dismissal on the ground that the working of a bank is required to be of the highest standard, otherwise the trust and confidence reposed in the customer should be shaken. Full stop. In regional manager, UP SRTC versus Utilal, 2003 3 SCC 605. The Honorable Court has observed as under paragraph 10. Paragraph 10. In Chairman and MD, United Commercial Bank versus PC Kakkar, 2003 4 SCC 364. The Honorable Supreme Court in paragraph has observed as under paragraph 14. Para. In this case, reverting back to the facts of the case in hand, the petitioner is found to have made transactions in connection with a number of bank accounts of a number of customers of their bank, and as well as the office accounts of the bank in a manner which is unbecoming of an employee of a bank. It is a case of loss of confidence in the petitioner as an employee of the bank. Full stop. Why 2008-9 SSC? One? Huh? How Nagaland? Tarot is I don't have by edition. It is a settled proposition that the principles of natural justice requires supply of a copy of the inquiry officer's report to a search-seated employee if the inquiry officer is other than the disciplinary authority. Full stop. It is also clear that it is also settled that non-supply of report of the inquiry officer is in breach of natural justice. Full stop. But it is also settled that failure to supply the report of the inquiry officer to a search-seated employee would not ipso facto result in proceedings being declared null and void, and the order of punishment non-est or ineffective. It is for the charge-seated employee to plead and prove that non-supply of such report has caused prejudice and resulted in miscarriage of justice. Full stop. If he is unable to satisfy the court on that point, the order of punishment cannot be set aside. Full stop. In the case in hand, though the petitioner has stated that he received a copy of the inquiry report much later than the order of penalty, the petitioner has failed to show how non-supply of the report of the inquiry officer at a belated stage has caused any prejudice to him and has resulted in miscarriage of justice. The aspect assumes relevance in the backdrop of the petitioner's clear admission as regards the commission and omission committed by him while he was serving in the officiating capacity of branch in charge of so and so branch and in his substantive capacity as office assistant multipurpose during the relevant time. As such, this court is of the unhesitant view that the supply of the copy of the inquiry report of the inquiry officer has caused any prejudice to him, resulting in miscarriage of justice in the process. Full stop. Para. Judicial review is not an appeal. From a decision, but a review of the manner in which the decision is made. It is power of judicial review is exercisable to examine whether the individual concerned had received fair treatment full stop. When an inquiry is conducted on charges of misconduct, the court is concerned to determine whether the inquiry was held by a competent officer or whether rules of natural justice are complied with. Full stop. Whether the findings or conclusions are based on some evidence. And whether the findings or conclusions are based on, or whether the authority entrusted with the power to hold inquiry has the power, authority, and jurisdiction to reach a finding of fact or conclusion. Neither the rules of evidence act nor of proof of fact or evidence apply to departmental inquiry. When the disciplinary authority accepts that evidence and conclusions received support therefrom, the disciplinary authority is entitled to hold that the delinquent officer is guilty of the charge. The court, in its power of judicial review, does not act as appellate authority to reappreciate the evidence and to arrive at its own independent findings on the evidence. The court may interfere only where the authority held the proceedings against the delinquent employee in a manner inconsistent with the rules of natural justice or in violation of statutory rules prescribing the mode of inquiry, or where the conclusion of finding reached by the disciplinary authority is based on no evidence. If the conclusion or finding be such, no reasonable person would have ever reached, the court may interfere with the conclusion or the finding. Post of the disciplinary authority is held to be the sole judge of facts. Post of. Having regard to the scope and ambit of the power of judicial review available under Article 226 of the Constitution, and upon consideration of the facts and circumstances obtaining the case in hand, this court does not find any reason, not to speak of good and sufficient reason, to interfere with the order penalty dated 7/2/2019, passed by the chairman of the bank as the disciplinary authority come appointing authority, who under the NRB regulation is found to have the power, authority, and jurisdiction to pass such an order. Post in such view of the matter, the other reliefs sought for by the petitioner in the form of the suspension order, and the relief sought for by the petitioner against the suspension order, the charge sheet, the inquiry report, and the order, the order passed by the appellate authority, etc., are found to have no merit. Resultantly, the requisition is found to be devoid of any merit, and the same is liable to be dismissed. The requisition is accordingly dismissed. There shall, however, be no order as to cost.
Not a question.
Can't help it. Thank you.